Americans don't agree on whether being born here should make you a citizen. That's not new. On the first day of Donald Trump's second presidential term, he signed an executive order titled Protecting the Meaning and Value of American Citizenship to end the birthright citizenship, a legal principle that has been essential to American identity. While the Supreme Court has not reviewed the legality of the order and the merits of the birthright citizenship, the order was blocked by several federal judges from taking effect through nationwide injunctions. Since its founding, the U.S. was conflicted over citizenship. Until the law governing naturalization passed in 1790, immigration to the U.S. was largely unrestricted, as the focus was on population growth. It only required that people reside in the country for just 2 years and be of good character, though it also stipulated that only free white persons were eligible. At the time, the nation was composed of indigenous tribes, European immigrants and their descendants, and the 20% of the population who were enslaved. The question of who qualified as an American was challenged when the Supreme Court held that no black person, slave or free, could ever be a citizen of the U.S., which resulted in the Civil War, abolishment of slavery, and the ratification of the 14th Amendment to the U.S. Constitution, which declared all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. At the end of the 19th century, again, the government challenged the citizenship of the children of Chinese immigrants, claiming that the protection of the 14th Amendment does not extend to the children of immigrants because they are not subject to the U.S. jurisdiction. It was argued that the children of Chinese immigrants were at the moment of birth subject to a foreign power because their parents were Chinese subjects. The principle of the 14th Amendment was affirmed in the 1898 ruling, saying that the amendment includes the children born within the territory of the United States of all other persons, of whatever race or color, domiciled within the United States. The fight over who gets to be an American does not end there. In the early 20th century, Congress passed the laws imposing an ethnic quota system, favoring certain ethnic groups over others by setting annual limits on each ethnic group of future immigrants based on the total population of each group in the country. This quota system lasted for about 50 years until it was replaced with a preference system based on skills and family relationships. During the Second World War, the U.S. imprisoned the children of Japanese Americans, claiming their loyalties were divided. They were forced to renounce their citizenship as a way of escaping confinement in concentration camps. In the 1950s, Mexican Americans were mistakenly deported during the sweeps that took place during Operation Wetback, a mass deportation campaign of Mexican workers who were brought through the government program to fill labor shortages resulting from drafted men during the war. Throughout the 20th century, Congress proposed legislation and constitutional amendments to end universal birthright citizenship, though none became law. The idea that you're a citizen if you're born here has long been contested as opposed to the idea where citizenship is passed down from your parents, one based on soil, the other on blood. The Trump administration's effort to restrict birthright citizenship is merely the latest turn in that struggle. The executive order that would deny citizenship to the children of both undocumented immigrants and lawful temporary immigrants, including those on years-long work and student visas, is essentially saying the children of immigrants are not Americans. The U.S. is not the only country having a debate over citizenship. French don't agree on whether being born here should make you a citizen either. A child born in France to foreign-born parents becomes French when they turn 18, or through an anticipated process, which is possible from the age of 13, provided that they have lived in France for at least 5 years since the age of 11. This is combined with the policy whereby a child born in France, to parents who, though foreign nationals were born in France, is a French citizen at birth. The decisive factor is not parentage, but birth and residence on French territory, which is a demonstration of will to live according to the laws that France has set for itself. The principle of birthright citizenship was established in 1515 as royal law, and it was written into the Constitution in 1791, making naturalization a common automatic and permanent right that allowed thousands of foreigners living in France to become citizens after 5 years of residency, even without their consent. It was also necessary to widely open up access to French nationality to recruit new soldiers for the country's armies, as France was facing a future conflict with neighboring countries. Naturalization then stopped being automatic in 1803, and the law required those born in France to foreign parents to declare their intention to become citizens and to settle in France upon reaching the age of 21, provided that they resided in the country for 10 years before the application. In 1889, the Parliament passed the law that automatically grants French citizenship to a foreigner born in France if one of the parents was also born in the country. At the same time, naturalization for immigrants became increasingly difficult as a result of anti-immigration sentiment. These paradoxical policies show that the government was only keen to integrate the second generation, not the foreign adults. During the Second World War, all naturalization acts were reviewed and used to denaturalize and deprive the citizenship from people of foreign origins, with a clear target of the Jewish population, claiming that poorly assimilated people should be excluded. In the mid-20th century, the French community that had been settled in Algeria since its colonization in 1830 was repatriated to France, which originated in 1954 with the Algerian War of Independence against French occupation and the subsequent official peace settlement in 1962. This mass migration of the Muslim population aggravated the troubled relationship with North African migrants in France, which led to the government's plan in the 1970s to deport 500,000 Algerians over 5 years, which was replaced with the measures for voluntary return, with little effect. In the period between 1993 and 1998, again, the law required those born in France to foreign parents to demonstrate their desire to be French, to acquire citizenship upon reaching the age of 16 to 21. The naturalization process became more difficult, with situations like French citizens of the second and even third generation being forced to prove their citizenship, in particular those from French families who were born in the colonies. The 1998 law restored the automatic acquisition of citizenship at 18 for those who had resided in France for a significant period. Recent discourse about the citizenship in France focuses on 2 questions: whether children of immigrants should be considered citizens at birth, and whether dual citizenship holders can be trusted. These questions touch on the ideas of equality, identity, and national security, with respect to 2 ideas of belonging. French on paper, the term is used to distinguish between the native French and those of foreign origin. In France, there have been continuous attempts to abolish the notion of birthright citizenship, so that only children born to French parents can have the nationality. The goal then, and now, is to deport and exclude the children of disfavored immigrants. People who believe that being French is earned or inherited argue that the focus should be more on assimilation rather than integration. With that same rhetoric, dual citizenship holders have been accused of being an obstacle to the integration of populations in the country and questioned for their dual allegiances. The idea of proposing a law that would limit the access of people with dual citizenship to jobs in government administration, public companies, and legal entities entrusted with a public service has been floating around, claiming they can't be trusted since you can't be sure where their loyalties lie. Arguments like this reduce your identity to nationality, ignoring the complexity of belonging. The debate over reforming the right to citizenship started with sorting between citizens and immigrants, and has now led to the sorting between citizens. Today, the Trump administration is weaponizing citizenship, not only to deport the unwanted, but also to control all those who remain. If the order were to go into effect, every person in the U.S. who wishes to pass down their citizenship status to their children will be examined, and will have to prove their ancestry to the government's satisfaction. The control over a system that decides who is in and who is out will give the government even greater control over the population. Mass deportation happened in every presidency, but it didn't look like this when the government had more empathy and principle to the humanity. It is argued that the administration's policies are about illegal immigrants, not the legal ones. But when you start weaponizing denaturalization to attack people who have different opinions or different political positions, make it a targeted operation to instill fear in immigrants, their families, and institutions that support and depend on them. It's not really about illegal versus legal anymore, especially when the government is the one not making distinction between those two groups. The case was brought up to the Supreme Court, and a supposedly conservative court ruled that the executive order Trump issued was unlawful and upheld birthright citizenship in a 6-3 decision. Birthright citizenship seems like a recurring theme, and the constitutional right was on debate for almost 2 years this time. While Americans do not share the same idea of citizenship, the fight over who gets to be American does not end. In that long fight, we should stop ignoring the fact that everyone in the United States is a child of immigrants.